tumelo na ki thebe e tla o phemisang lefu nyakalo ki fuma ni tsileng ya mo rena o tla ba jwang ha ke siya kubo ye na e bola ha ke re ke mo futsana o re tjhe o na le nna ha ke re kgoro ya hana o re tjhe o tla kena. God bless you all. Ke a le dumedisa, and I thank you for your hearing. I thank you for your patience. I thank you for your loyalty, fortitude, and pride. It is indeed true that I am determined to save succeeding generations from the scourge of war, which twice in our lifetime has brought untold sorrows to mankind, and to reaffirm faith in fundamental human rights, in the dignity and worth of the human person, in the equal rights of men and women, of nations large and small, and to establish conditions under which justice and respect for the obligations arising from treaties and other sources of international law can be maintained, and to promote social progress and better standards of life in larger freedom. And for these ends, to further practice tolerance and live together in peace with one another as good neighbors, and to unite our strength to maintain international peace and security, and to ensure by the acceptance of principles and the institution of methods that armed forces shall not be used save in the common interest, and to employ international machinery for promotion of the economic and social advancement of all peoples. Have resolved to combine our efforts to accomplish these aims. Accordingly, our respective governments, through representatives assembled in the cities of all countries, who have exhibited their full powers found to be in good and due form, have agreed to the present Charter of the United Nations, and do have established an international organization to be known as the United Nations. The Secretary of the Judicial Service Commission, Mr. Sello Chiloane, our daily deeds as ordinary South Africans must produce an actual South African reality that will reinforce humanity's belief in justice, strengthen its confidence in the mobility of the human soul, and sustain our hopes for glorious life for all. Unless you disagree with the father of our rainbow nation and the supremacy of the Constitution and the rule of law, you will stop maintaining a reality of depriving me my inalienable rights enshrined in the Bill of Rights, including the right to be heard urgently by the Judicial Conduct Committee. to tell me to wait while you come to and from work every day only sustains criminal activity, corruption, apartheid, or misconduct. In the event you go to work to fight against corruption, but not call for me a hearing. Not call me for a hearing. Know it to be true that you are not doing what you are paid to do and administer justice to all people alike, and subsequently defeats the mandate of the office of the Chief Justice. The reality of this particular matter is such that one cannot escape the aggravating realities that the other is facing as a result of an act or omission of by another, which ultimately results into oppression. The oppression that we have been guarded against since birth of our nation. And this particular oppression is such that we cannot do away with the reality that Papa Ute, I am the defender and protector of the Republic of South Africa. The Republic of South Africa is one sovereign and democratic state inter alia founded on the core values of human dignity, equality, the advancement of human rights and freedoms as contemplated in terms of Chapter 1, Section 1 of the Constitution of the Republic of South Africa, Act 108 of 1996. Which is the supreme law of the Republic. Law or conduct inconsistent with it is invalid to the extent of its inconsistency, and the obligations imposed by it must be performed diligently and without delay. Fear, favor, or prejudice to all people equally. Any person who is against me is simply against the supremacy of the Constitution and the rule of law that must at all times be upheld, defended, and respected to promote the unity of the nation and that which will advance the Republic of South Africa and her people, including the African Union Agenda 2063 in promoting the National Development Plan 2030, having regard of task number 13 at Goal 4 of the Defense Force Goals and Tasks. We have a reality in the judiciary or the jurisprudence where Lieutenant Lizzie Hange, as a complainant, has filed this particular complaint on 19 August 2020. And in this particular reality, in her statement, which is available in Record of State, she reaffirms the actual realities of what had happened in that particular day and says, on the 19th of August 2020 at about 1320, unknown person knocked at my door. When open the door, the person come inside together with the female unknown to me and the child. He then called his friend, a male guy, to come inside and said, "Ke fihlile gae," in Setswana, meaning I am home. Then I asked him who he is, of which he responded that he is Mangolele. I then remembered that he is the guy who used to stay here. He then introduced the lady and his friend to me, and then I then called Commander Dulamo, my divisional officer, and she said she will come back to me. Commander Dulamo then called back and gave Commander Kombrik Bopso called cell phone numbers. I called Commander Combring, of which he promised to call me back, of which he did, and further tell me he's gonna call the military police and he will also come up to my house, and that's where the military police arrived at my house. So this reality is such that the statement here, it says on the 19th of August 2020, about 20 past 1, unknown person knocked at my door. When I opened the door, I presume the person came inside together with the female unknown to me and the child. That particular child, in this judgment by the Honorable Jacobs J., the magistrate of Simonstown, he then comes and forth and says, her brother opened the door and the accused, together with a lady and a small dog, pushed a suitcase inside the house. The child is now subsequently referred to as a small dog. The jurisprudence holds it to be true that my daughter Aluta Songelwa is a small dog. And each time I am deprived a hearing, this reality persists. And as it persists, it's a reality that must be corrected. And in correcting that reality, the covering factor here is this particular complaint that the Judicial Conduct Committee has received and is actually awaiting for hearing. That's all. Hearing. That's all. And that hearing will not happen when the Secretary of the Judicial Conduct Service Commission or the Secretary of the Judicial Conduct Committee does their respective duties. I am demanding that particular hearing with all due respect when we look into the explicit terms of Section 237 of the Constitution, which obligates all constitutional obligations to be performed diligently and without delay. It is not me who wrote the law. I simply defend the law. And in defending the law, we cannot be sitting in a reality where we delay the law. For the Bill of Rights is the cornerstone of democracy in our republic. And the reality of this particular situation is that this matter was filed diligently and without delay. And we have a situation in which the law knows it to be true that the Constitution is the supreme law of the Republic. Law or conduct inconsistent with it is invalid to the extent of its invalidity, and the obligations imposed by it must be fulfilled or performed diligently and without delay. There is simply no excuse for any person not to fulfill the obligations imposed by the supreme law, which provides equal protection and benefit to all people in sort of a better life for all. There is no agenda that may derogate from the Constitution. And in the preamble of the schedule, the Minister of Defense and Military Veterans has, under Section 62L of the Defense Act 2002, made the regulation in the schedule to say, whereas the Defense Force is a national asset which is mandated under the Constitution to be structured and managed as a disciplined military force and in accordance with the principles of international law governing the use of force. And whereas the Defense Force is essential in the defense of the Constitution, the territorial integrity and national sovereignty of the Republic and our democracy, and whereas the Defense Force provides a soldiering career wherein members entrust their inalienable right to life, which is guaranteed in the Bill of Rights of the Constitution to the nation and the state. And whereas it is an unavoidable reality that when a soldier is recruited, he and his family becomes a part of a larger Defense Force family to share in the joys, anxieties, and sometimes unfortunate outcomes of service, including maiming and death. And whereas it is essential for an effective mechanism to be created to provide for the necessary duty of care to the soldier and his or her family, and whereas it is therefore necessary to create a working environment for the soldiering professionals that is positively conducive to discipline, and whereas these factors define the uniqueness of the soldiering profession, and whereas in line with the uniqueness of the soldiering profession, the Defense Force Service Commission has been duly established in terms of Section 62A1 of the Act as a statutory body. And this Defense Force Service refused to grant me a hearing, which I am requesting humbly from the Judicial Conduct Committee. You cannot apply the law without hearing. Hearing means impartiality. Impartiality means to hear people. This one say, dulce, dulce. Make the hearing happen. And in doing so, you will understand it to be true that this unavoidable reality is true to my life. You have responded on 22 November 2021. It is almost now the end of the third month without a hearing in this particular regard. Put these terms to practice. And in putting these terms to practice, understanding that Papa Oteng and the reality that saving lives has always been what I do, it is not a lie that you took me from this particular dignity, a wardrobe that lived this life or this existence, a bedroom, my golf clubs, and my dignity that allows me to reside and rest in this particular place. This is the human dignity that has been taken away. My efforts in traveling the world, including the Reunion Islands where I got that volcanic rock, and Mombasa where I got these figures from. The simplicity of my life, when the simplicity of my family life, my grandmother and the joy that she had with me, you took that away. My children and their residence, the reality of having all this The reality of owning a vehicle that the police cannot bring back its car keys that have been taken in terms of Section 201A of the Constitution. You act as if I do not have this particular car that is required for me to execute my duties, for me to escort my family whenever I can, and for me to be an equal person before the law. You act as if these things are not there. You act as if the supremacy of the Constitution does not protect this particular vehicle and this particular human dignity. I hear on the radio now behind me a person talking about corruption, and then that person has taken these particular car keys. And as if he owns this car. When you report this reality to the police are doing nothing. And this is my vehicle. It is my own property that is protected in terms of the Constitution. My son, the last time I made him his birthday, he was turning 3 on this day. You pretend as if he does not exist. You pretend as if he is not there. That was when the incumbent president, Cyril Ramaphosa, sent this particular person who will tell you that the president, through the state attorney, sent him to do this particular, to achieve this particular reality. Where you took me from what you have seen before, now you expect me to live there, which takes us back to Sol Plaatje when he traveled around the country in a bicycle on 25 July 1913, after the Land Act was passed. The SANNC convened a conference in Johannesburg and resolved to raise funds that would be used to send a delegation to Britain which would appeal to the imperial government against the act. Officials in the Department of the Native Affairs requested the SANNC not to proceed with their appeal, but the SANNC resisted these attempts. Then on 14 February 1914, the SANNC met and chose 5 members to go to London. And to cut the long story short, the Crown refused and said it is a governmental matter. This is my constitutional address. The fact that I am under a roof is unlawful relative to the act taken to give me this particular constitutional address. And the reality of this particular constitutional address is such that I did not bring my belongings to that particular reality. I did not. Somebody hired a truck, they hired people, they motivated them, they said, hey, you are going against the commander, and then you are not going to discuss anything with him. You take his stuff, you put it on the street. It was an order. Question is, to all people, in all fairness, is that order a lawful order? Where in our constitution, after the sacrifices of our mother and father to have achieved the constitution, which is now our supreme law, not the incumbent president Cyril Ramaphosa or any person or parliament, we have overcome the supremacy of parliament when we adopted the constitution in 1994. You must understand that particular reality. Parliamentary supremacy is no more. It is now constitutional supremacy. And when you take constitutional money to pay people to achieve this constitutional reality, you are simply telling me, Mangolele, stay in that reality. And each single day you tell me that, Mangolele, wait, Wait, we will hear you. We are busy assisting the people who put you there, and then asking them to promote us, and then all these things, and all these things. You are not acting in accordance with the Constitution and the law. Ke nnete se se. A se maaka. It is not a lie. Constitution and the law is not only for lawyers. Constitution and the law is for everyone. That is why we say everyone, including the trees, the stars, and everyone that you would know as one. The reality of this is aggravating. There is no right in the Bill of Rights that the state can respect, protect, promote, or fulfill in this environment that is harmful to the health or well-being and cannot be protected for the benefit of present and future generations through reasonable legislative and other measures that prevent pollution and ecological degradation, promote conservation, and secure ecological sustainable development and use of natural resources while promoting justifiable economic and social development. If you do not understand that constitutional reality, kindly read section 24 of the Constitution, which tells you about environment, and understand the constitutional reality of this particular matter. The truth is that I serve and defend my country and its people in accordance with the Constitution and the law, and with honor, dignity, courage, and integrity. The Constitution of the Republic of South Africa, as adopted on 8 May 1996 and amended on 11 October 1996 by the Constitutional Assembly, provides us with a preamble in which we, the people of South Africa, recognizes the injustices of our past, honor those who suffered for justice and freedom in our land, respect those who have worked to build and develop our country, and believe that South Africa belongs to all who live in it, united in our diversity. We therefore, through our freely elected representative, adopt this Constitution as the supreme law of the Republic, so as to heal the divisions of the past, and establish a society based on democratic values, social justice, and fundamental human rights. Lay the foundation for a democratic and open society in which government is based on the will of the people, and every citizen is equally protected by law. Improve the quality of life of all citizens and free the potential of each person, and build a united and democratic South Africa able to take its rightful place as a sovereign state in the family of nations. Hosi katekisa Afrika, Mudzimo futsuzetsa Afrika, God sien South Africa, God bless South Africa, Nkosi sikelela iAfrika, Morena boloka setjhaba sa heso. May God protect our people. Good people, this is the manual adopted each time we recognize the injustices of our past. This is the truth, that we believe that South Africa belongs to all who live in it. And when we act to promote for the defense of the Republic and for the matters connected therewith, be it enacted by Parliament of the Republic of South Africa as follows. The Defense Act number 42 of 2002. Aluta Songelwa is my second-born daughter. My firstborn is Nyiko Mangolele, whose face you see there. An exact replica of Aluta Songelwa, if you understand the nature of persons. These are my children. And these particular children are neglected by law. For what good reason is something I will tell you about. However, the reality is that as we do act to provide for the defense of the Republic and for matters connected therewith, what is of paramount importance in every matter concerning the child is their best interest. These are my children, Nyiko Mangolele and Aluta Songelwa. I am their father. Nyiko Mangolele is my firstborn son, whom I have last seen on 3 November 2019. Aluta Songelwa is my daughter, whom I'm unable to provide for care and contact. And to give effect to the certain rights of children as contained in the Constitution, to set out principles relating to the care and protection of children, to define parental responsibilities and rights, to make further provisions regarding children's courts, to provide for the issuing of contribution orders, to make new provisions for the adoption of children, to provide for inter-country adoption, to give effect to the Hague Convention on inter-country adoption, to prohibit child abduction, and to give effect to the Hague Convention on International Child Abduction, to provide for surrogate motherhood, to create certain new offenses relating to children, and to provide for matters connected therewith. If it is in the best interest of the child's family must be given the opportunity to express their views in any matter concerning the child. And as mandated in terms of Section 6.3 of the Children's Act, and that every child of such age, maturity, and stage of development so as to be able to participate in any matter concerning that child has the right to participate in an appropriate way, and views expressed by the child must be given due consideration as contemplated in Section 10 therein. It is therefore without fail, fear, favor, or prejudice that in order for the state to respect, protect, promote, and fulfill the rights in the Bill of Rights, the express views of Malenja Millicent Sankobe, Tumeka Songelwa, Nyiko Mangolele, and Aluta Songelwa must be secured at state expense to constitutionally, lawfully, and validly conclude the requested family counseling. And in addition to the meaning assigned to the term custody and access in any law and the common law, the terms custody and access in any law must be construed to also mean care and contact. It is correct that we need not to derogate from a common point of reference when we talk about care and contact. This is in terms of Section 1(2) of the Children's Act, which delineates what you are seeing right now. Now, care is defined is in relation to a child includes where appropriate within available means to provide the child with a suitable place to live and living conditions that are conducive to the child's. But let's come to a suitable place to live. This is not a suitable place for a child to live. And I went to the people who uphold, defend, and respect the Constitution as the supreme law, and those particular people came back to say, no, you must live on the streets. Your children must live on the streets. When the court upholds eviction order against Navy boss, has released on the newspaper for the universe to know this particular aggravating reality. This reality is something that one cannot run away from. It is a reality that is in the Constitution. And to tell you the truth, in 2011, I have represented myself before the Children's Court. And the Children's Court directed the Department of Social Development, in which Miss Natalie Choto had this to say about the matter. The concerned family is known to our office since April 2011. Our office received a care and contact application made at Simonstown Children's Court by the biological father, informing the court that he had been denied access to the consent child, who was sent outside the province to the family members without his consent. The biological parents were separated at the time of the application with the prospect of a divorce. The biological father was the applicant with regards to care and contact. The biological parents are separated pending their divorce proceedings. The biological parents have separated resident and the concerned child is in the care of the biological mother, according to the biological father. The biological mother sent the consent child to the maternal grandparents without his consent on 24/07/2010. The biological father made an attempt to fetch the consent child from the maternal grandparents and was greeted by aggression by the maternal grandfather. And the truth of that particular case was an order in terms of the Children's Court, in terms of Section 46 of the Children's Act. File reference number 14, as you can see in that particular regard, where the parties were Mangolele, Sylvester Volani, and Mangolele Malenja Millicent. It is correct that we were married, and the law is not such as true and binding to all in terms of Section 165(5) of the Constitution. And in that particular reality, the parties were greeted with an order in the following terms. Where the child consent to remain in the care of his biological mother, major decisions regarding the child to be made by both parents consulting with each other. In the event that they cannot reach an agreement, the party may approach this court on application for a specific order. The biological father granted reasonable access and contact with the child to be exercised as follows. The biological father is entitled to have custody of the child every alternative weekend and every alternative school holiday. The first said weekend to be on 28 October 2011, from 1500 on the Friday preceding the weekend to 1600 the last day of the weekend. Weekends to include any public holiday on the preceding Thursday or following Monday, and the above period's time to apply accordingly. The biological father is responsible for collecting and returning the child on his weekends and holidays. The biological father is entitled to see the child every Tuesday between 15:30 and 18:30, and every Wednesday between 14:30 and 17:30. For the purpose of the above, the biological father is entitled to collect and return the child from and to the mother's residence. If the biological father is unable to exercise the above rights, he is to inform the mother at least 12 hours before in the case of weekdays and 72 hours in the case of holidays and weekends. And that is the order issued on 17 October 2011 by the Magistrate Court of Simonstown. In relation to Aluta, on 17 October 2019, the court, and I mean this to be true because this is 17 October 2011 and 17 October 2019, the Pretoria High Court granted Mr. Sylvester Volane Mangolele is granted rights of access to his minor daughter Aluta Songelwa during the weekend of 18 to 20 October 2018. The people that were to make that particular reality possible were the President, Minister of Defense, National Treasury, National Prosecuting Authority, Minister of Justice, Deputy Chief Navy, Chief of the Naval Staff, Director Naval Logistics, Rear Admiral Junior Grade Gogi, and Minister of Police. That did not happen. Living conditions that are conducive to a child's health, well-being, and development are, as you have seen before, and that is the reality that is opposite to the picture that you have seen there. A home that the child can be rest assured at and then comforted in and grow accordingly and play whenever possible and be with his friends, as one can see Nyiko Mangolele happy at home playing with his friends in his growing age while he visited home once in 2015. And here is the reality of this son in that particular home, where we can even go outside and have leisure time accordingly. Nico has got friends, has got dignity, has got human rights, and has got a father who saves lives in all possible ways and all possible means. The necessary financial support in this particular regard one will have to understand that it comes from nowhere else but where Daddy is employed. And where Daddy is employed is the reality where one needs to take into account the nature at which the contract of Daddy ends on excuse me. Excuse me. Daddy's contract ends on May 21, 2023. And whatever that has happened, ancestors are talking. And whatever that has happened has been the maladministration of that particular contract of that you see in this particular reality. And that particular maladministration manifests itself in the DOD PESOL system, where the application reason is offensive behavior in terms of Section 105 of the Defense Act. Remembering that all members in the Defense Force must act in accordance with the Constitution and the law. And in acting in accordance with the Constitution and the law, simply tells you that you need to follow what the Constitution and the law says. And when we go to Section 105 of offensive behavior, you may pause the video when you want to do so. Please understand that it requires conviction and it requires a person to have been the accused. I put to you that I was never accused or stood before any court in relation to a conviction in terms of Section 105. I am not imprisoned to jail. I'm not convicted to imprisonment to jail for 5 years or less. I have never been formally introduced to these particular allegations in record of court anyway. And that particular reality is that the principles, and in particular, the principle that the Defense Force must respect the fundamental human rights and dignity of its members and all persons when exercising any power or performing any duty in terms of this act. People did not have such regard. You ask yourself what happened to it. What happened to that fundamental principles when you understand that officers are gentlemen and gentlemen are men of principle. And the only principle that we know in the Defense Force are these principles that obligates all members in the Defense Force not to obey a manifestly illegal order, amongst other things, and that the Defense Force must primarily have a defensive orientation and posture. The truth of this matter is Section 105 of offensive behavior as enacted is something that did not happen in reality, hence a false entry in this particular regard. I was never called. I never knew. I just saw my salary stopping. Boom, salary stopped. Hey, what do you do when salary stops? You go to the to HR normally. I could not go to HR because I was blocked. I could not enter for whatever reason I do not know. Could not enter a military unit. Why? I don't know. Any written reasons why? No written reasons why. What tribunal took place in that regard? I don't know. That is the reality of what had happened. And in that particular reality, we come to this particular termination authority. And this termination authority was, the referral is Mr. Marcel Devet. You will have to call Mr. Marcel Devet in that phone number. You have it before you. I have made it simple for you. I have investigated the matter. I have given it to your table. and then I see that you are seeing it, and then I understand that there is being a delay in calling me, and then that particular delay defeats and obstructs the administration of justice in any event. So that delay must come to an end. Because my son is supposed to see me every Tuesday and every Wednesday. My salary is supposed to come out from the Defense Force, nowhere else. I cannot be expected to go and lie to people and say, no, I'm asking for employment from you to be a security in your gate, and you ask me, what's your previous employment, and then support the lie. Say, no, no, no. They say, I'm not working. While what you see here is work at its best in service and defense of our country and its people. All I am asking, Tate Chiloane, lo wena Ntate Mlungisi, please lungisa le ndaba. Lungisa indaba. Section 1656 of the Constitution still is entrusted on you, Mlungisi, with all due respect, as the acting Chief Justice. Lungisa. Right now, I don't have money. I don't have energy to even ask anybody money. You know, I haven't eaten anything. And it is the truth. I sit here, I think, where am I, where? But people are going to work every day to say we are the Judicial Conduct Committee, we discipline judges. We make judges account for their judgments when a complaint is brought before us. I did that. Make it happy. And you must understand, Hore, now what I see here, it's an opportunity of growth for the nation in terms of the National Development Plan. What I see the Judicial Conduct Committee having to be everywhere in every province to serve justice to all people. Because justice is indeed administrative. Administration is indeed what many other went to school to learn and do. And that particular multifunctional facet of people would make wonders in ensuring the development and sustainment of our country and its people going forward, not stuck in one simple administrative era where you have the Minister of Corrections. Please correct the error. Correct the error. Minister of Correction does not want to correct the error. That is the democracy that we do not want. That is the democracy that the National Defense Force cannot stand for when guarding this constitution, which says that everyone have got a right. Everyone is equal. Do not confuse the status of one called the army, one called the air force, one called this, and then say that they are not equal before the law. They are equal before the law. And in that particular reality, I am doing this as a job to educate and serve and defend my country and its people against the same mistake that is happening perpetuously to only subject our people to live and struggle, strive, and attempt for freedom. It was embarrassing indeed to hear the national prayer being sang in the opening of Parliament, and people are still saying, God, please, in the highest note, we want to live and struggle for freedom. It's painful to observe, as if we have no brains, as if we have no knowledge of the meaning of the words. It is Puthuku. Seriously, excuse me, I'm running down on some hay fever. But anyway, in service and defense, I'm hay fever or no hay fever. Things need to happen. And when we make things happen, we do them in this particular fashion. Safeguarding and promoting the well-being of a child It is what we must do, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical or emotional harm or hazard. How do you think my children are feeling right now without their father? How do you think my children are feeling when they hear other children saying, Papa, 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 and then they look around, no, that is not your Papa. Your Papa is busy shooting videos there, talking to the people, asking them to respect your rights, and your Papa, those people, they have locked him away somewhere. Let us be true to our mandate. Let us be true to what the supremacy of the Constitution and the rule of law dictates. Let us be true to the fact that Papa Oteng and then I defend and protect the Republic of South Africa. Not only do I do that as the member of the South African National Defence Force in my juristic nature, but also as a citizen equally entitled to the rights and privileges and benefits of citizenship, and equally subject to the duties and responsibilities of citizenship. And I know it to be true that national legislation does provide for the acquisition, loss, and restoration of citizenship as contemplated in Section 3 of the Constitution. As the sixth president, a president is a person who upholds, defend, and respect the Constitution as the supreme law and promote the unity of the nation and that which will advance the Republic. That is like that. That is the president. Every time you hear the term president, they simply mean the person who upholds, defend, and respect the Constitution as a supreme law at all times. Don't worry about what he is saying, what. When we are in the subject of law, the president at all times must uphold the law. He must defend it. That's why he's a commander-in-chief of the defenders of the Republic. You understand? I'm defending the Republic from corruption. Corruption is an enemy. That's why it's about fight. You cannot fight something that is not an enemy. Now I'm not fighting it, I'm ending it. Just give me a hearing. Record it. Let people see the truth. Let our country go forward. I'm more into economic development and social development and our growth of Africa as a continent at large. I have responsibilities. And as I say to you that, as the sixth president of a democratic Republic of South Africa, I have fulfilled without delay the constitutional obligations at Section 12 and 13 of the Bill of Rights to ensure that no one may be subjected to torture, slavery, servitude, or forced labor, and have determined by proclamation for all to live and enjoy freedom in the universe, our home, having regard of the founding value or provision at Section 4 of the Constitution. We just have a reality in which the Chief of Defense, arbitrarily or without just cause, refuses to, with impunity, to function in terms of Section 14 of the Defense Act, which simply means that a person paid a salary to act in terms of Section 14 is not doing what he or she is paid to do. Hence, a dispute that can only be resolved by the application of law decided in a fair public hearing. I have nothing personal against any public official. I have on 1 July 2021, immediately I came out of jail and then reconnected my thoughts and then acted according to the Constitution and the law, made a submission to return to unit and reinstitution. In service and defense of my country and its people, I act in terms of Section 1995 of the Constitution of the Republic of South Africa, Act 108 of 1996, and respect the functions of the Chief of Defence of the South African National Defence Force in terms of Section 14 of the Defence Act, obligating compliance to statutory provisions that the Defence Force must respect the fundamental rights and dignity of its members and of all persons. See Section 2G as I have shown you before. By providing me and my children with a suitable place to live effective immediately, reinstituting immediately payment of my salary including all benefits, respecting, protecting, promoting, and fulfilling my rights enshrined in the Bill of Rights, Chief of the South African National Defence Force, you, myself, and any member of the South African National Defence Force work for the state that must respect, protect, promote, and fulfill the rights in the Bill of Rights as obligated in terms of Section 7.2 of the Constitution. To engage with me is how you respect, protect, promote, and fulfill my rights enshrined in the Bill of Rights, and stop punishing me for an act committed by other persons and intimidating or coercing me to do or to refrain from doing anything. Severe pain or suffering, both physical and mental, is intentionally inflicted on me. In simple terms, I am tortured, and the opposite of my constitutional guarantees not to be tortured in any way is achieved. I could employ Rule 612A of the Uniform Court Rules to resolve this dispute by the application of law decided in a fair public hearing before the High Court of the Republic of South Africa, but I am being forced to believe that a person, Justice Hlophe, or organ of state, Judge President, must interfere with the functioning of the courts or a gross violation of an imposed constitutional obligation provided for in terms of Section 1655 of the Constitution. I am forced to believe that it is lawful and acceptable to declare any person a vexatious litigant without hearing such a person or granting him an opportunity of being heard as obligated by the statutory provisions of Section 21B of the Vexatious Proceedings Act 3 of 1956. And in any event, the judiciary refuses to apply the provisions of Section 21C of the Vexatious Proceedings Act, and at any time rescind or vary an order so given. Yet I am forced to believe that the court order is in terms of Section 21B and 1C of the Vexatious Proceedings Act. I submit that the judiciary is corrupt, and it is one critical deadline that must be arrested through immediate directed interventions. Please give me a chance to explain and debrief. I am caused to believe that it is wrong to do right and good for the country and its people. I am forced to believe that it is wrong to father my children. I am forced to believe that corruption is more powerful than the South African National Defence Force. I am forced to believe that the Constitution is not the supreme law of the Republic. I am forced to believe that it is right or constitutional to be presumed guilty until proven innocent. I am caused to believe that no one has the right to represent themselves in court. I refuse to believe this false. I refuse to believe that it is lawful to arbitrarily or without just cause discharge a person who is simply doing his job to save the Republic hundreds of millions in operational cost. I am without accommodation. I need accommodation. Theoretical differences shall be elaborated in an appropriate, independent, and impartial tribunal or forum, compensation board, constituted in terms of Section 57 of the Defense Act and Section 57(2) of the Defense Act provides that any member of the Defense Force who has suffered, any member or former member, any member or former member of the Defense Force who has suffered any damage or loss as a result of an act or omission arising from any training or service under this Act, whether or not legal proceedings have been or are to be instituted, may in writing apply to the compensation board established by subsection 3 for the compensation, setting out fully the grounds on which the application is based, the extent and nature of the damage or loss, and the compensation desired. I am without salary for the past 34 months at that time when I sent this, as a result of abuse of power and gross violation of the Constitution or the law, gross misconduct or inability to perform the functions of office. In the past 34 months, people had operated their office based on personalities and not professionalism. There is a decline in critical capabilities. In no event did the President notify me in writing of any complaint or charge made against me and of any action proposed to be taken in respect thereof, nor calling upon me to come show cause in relation thereto, to my permanent commission being cancelled as obligated in terms of Section 54(3)(a) of the Defense Act. It is disrespectful to the authority of the President not to refer to me as Mr. instead of my rank. In no event was I convicted to imprisonment for a period not exceeding 5 years following an obligation imposed in terms of Section 105 of the Defense Act, as unlawfully and intentionally misrepresented in the DoD personal system to cause me actual or potential prejudice from 8 August 2018. In no event was I sentenced to a term of imprisonment by a competent civilian court without the option of fine, or a sentence involving discharge or dismissal was ever imposed upon me under the Code of Military Discipline, following an obligation imposed by the statutory provisions of Section 59(1)(d) of the Defense Act to qualify the letter dated 17 August 2018. An effort to obey the applicable terms, number 4 Cable Hill Road, Simonstown, 7975, on the letter dated 17 August 2018 from the Office of the Chief of the South African Navy, saw a uniformed member of the SANDF unlawfully detained in a civilian prison. Such act or omission only proves that to believe and put to action the first applicable terms of the letter dated 17 August 2018 from Chief of the Navy only invites imprisonment. Security services of the Republic consist of a single defense force structured and managed as a disciplined military force. whose primary object is to defend and protect the Republic, its territorial integrity and its people in accordance with the Constitution and the law and the principles of international law regulating the use of force. Read with Section 200 of the Constitution when you're looking at Section 1991. It is these security services I demand peace in my life from. I ask that my family suffers no more as a result of the unlawful, intentional, and serious violation of my dignity, farmer, or reputation, or corpus, physical security, or privacy. I am a person. I do feel pain. I do hurt. And I do want to be happy raising my family in service and defense of my country and its people. I cannot fail or surrender to corruption, criminal activity, apartheid, or misconduct. As a senior officer leading thousands of subordinates in the South African National Defence Force, and still accountable to all 60 million people or more in the Republic of South Africa, there is indeed a lot that must be explained, and it is correct to perform constitutional obligations diligently and without delay as provided for in Section 237 of the Constitution. I must admit, this matter is on public domain. The people of the universe await an end to this matter, as I do. I may not mislead you, sir. Life goes on each and every day, and I have written a sworn statement on 24 February 2021, taking over as the 6th President of the Republic. I do trust that all people are in jail as a result of a person writing a sworn statement against them. Equally so, in service and defense of my country and its people, I did write a sworn statement against the 5th President. And such statement was written while I was in Polsmo, and it was given to the people. The national flag of our republic is undermined by a few in critical capabilities to keep oppressed on the muddy ground of Simonstown since 20 June 2018, only to indemnify the state or any person against any unlawful act against a member of the defense force and his family, which includes Nico Mangolele and Aluta Songelwa, whose best interests are of paramount importance in every matter concerning them. It is true. And as this particular truth prevails, you will understand it to be true that we have a reality in which judicial officers suffer from incapacity, are grossly incompetent, or are guilty of gross misconduct as a result of a derogation from a section mentioned in column 1 of the table of non-derogable rights to the extent indicated opposite to that section in column 3 of the table. And exceptional circumstances, including but not limited to a state of homelessness, internal political instability, or national security, are invoked as a justification for torturing and subjecting our country and its people into slavery, servitude, forced labor to live and struggle, strive, or attempt for freedom in South Africa, our land. I am indeed divorced. It is indeed true that I have done all efforts that any other parent can do to lawfully obtain care and contact of his children. It pains me each and every day knowing that each and every day the Judicial Service Conduct Committee is available or must be available for all people. If it is not available, we are acting in contrast to the Constitution. and its deliverance to the people. We have employment opportunities that we must fulfill as the government. We have skilled personnel living at home unemployed, and then we have a delay in our democracy and developmental growth as a nation and a continent as a result of no, you did it, you did it, you did it, you did it, and then you are causing us to lose faith in justice. Imagine how my family is feeling. The ones that were there when they saw me getting married. They were there, they saw it. What is happening? Out of that particular marriage, there came a child. They want that child. I cannot go and then force Millicent Sankobe to answer my phone. She blocked me. I call her using a private number. She hears it's me. She says whatever, no, your son will call you, but the son never calls. I need intervention of the law. And I will not stop believing in law because of criminal activity happening within the law that I must discipline for the sake of our country and for generations to come. Reason is the soul of law. It is like that. You cannot run away from the existence of law. If law ceases to exist, so does reason. Then this particular video does not have any meaning to you. Because for me, if I'm to tell you, I'm not going to come there at the Judicial Service Commission and repeat what I have said here in this video. No. I am an intelligent person. I understand exactly what I am doing. I understand it exactly that when I send you a link of this particular video, you will understand what I will put forward there. However, we need to come together and come to terms. And in coming to terms, there needs to be a ventilation of these particular issues. And they must be ventilated fairly and openly in terms of Chapter 10 of the Constitution. Let us uphold the rule of law and its supremacy. Let us not let the law to lose its meaning. We cannot. That will be only failure to our children and their children's children, and they will not forgive us. And I cannot do this on my own. I cannot come there. Hey, Judicial Service Commission, I'm here. Yeah, listen to me. No. And I do not act in contrary to what I say. I am true to my terms. Please be true to your terms as you go to work also. I thank you. Papa Ote. God bless you.